Yeah, good afternoon, friends. Welcome to IDPS 2021. We will start off with Dr. S.P. Arya, President of the National Governance Council of FDPPI, formally welcoming the audience. Over to you, Mr. Arya.
A very good afternoon to you all, distinguished speakers, delegates, and friends. In this second edition of Indian Data Protection Summit 2021. We held first of the IDPS in 2020 virtually, just after the first wave of COVID-19 pandemic, which was, in a way, was a success. And we are here once again this year with much more knowledge contents on data protection, security, and data privacy. It is said that data is the new oil, but for me and at least for most of the people here on in our forum, the data is an important and most valuable asset, and whole organization revolves around it. Gentlemen, before this pandemic, the whole world has been facing enormous challenges in keeping the data being generated in digital world safe and protected. Pandemic added more challenges as workforce started. Just a minute, let me, am I audible?
Yes, yes.
Okay, yeah. Pandemic added more challenges as workforce started working from home. According to new studies and surveys, during and post-pandemic cyber threats attacks increased by whopping 300% in 2020. Every month we hear few incidents of large-scale ransomware attacks, hacking, and data theft. Many a time the system controls are compromised, like in case of oil fields in US. Just to quote few statistics around this increase, let me quote here. The data exfiltration incidents increased by 55%. Attacks using phishing emails increased by 51%. Account takeover threats increased by 44%. Malware downloads increased by 36%. Ransomware attacks increased by 35%. And application targeted attacks rose by 20%. Please note, and it was really surprising and shocking that between February 20 and May 2020, more than 500,000 video conferencing users were hacked into and their personal data was compromised. And this increased day by day, and all the video conferencing companies like WebEx, Zoom, and Polycom, everybody has to work fast and then protect their users from such hacks. Cyber attacks increased 23 times in 2020 in comparison of attacks in 2015. 23 times, staggering 23 times, please note. Okay, while the organization and governments across the world are having very high concerns about their systems and data hacks, they are more concerned about the protection of personal and sensitive data they have. While smart AI-based software and hardware tools are being developed and deployed to protect its personal and sensitive data, nations are enacting strong data protection and cyber security laws and implementing these so that the hackers and rogue software guys do not steal your data. And if they steal, they are dealt with strictly according to the laws. As of now, around 128 nations, 66% have enacted and implemented such laws. Prominent are GDPR in Europe, and US has multiple state-wise laws like CCPD in California, UK Dppi 2018, Brazil LGPD 2018, and just a minute, which was enforced in 2020. Australia, a bunch of several territory-wise and state-wise information privacy laws. China recently adopted PIPL in 2021. Though GDPR covers the whole European Union, but individual nations have their own laws as well to cover up their special provisions. Just to conclude on data protection privacy laws, let me inform you that 66% are with fully implemented privacy laws, and 10% nations are with draft legislation only. 19% has no legislation at all at present, and 5% nations are with no data at all. Before we move ahead, let us just understand the difference between, I will just take off for a minute, difference between privacy and security. And it comes down to which data is being protected, how it is being protected, from whom it is being protected, and who is responsible for that protection. Security is about protecting data from malicious threats and hackers, whereas privacy is about using data responsibly. The laws enacted and implemented and enforced thus very well can have these provisions of audits, penalties, and capital punishments so that people use and keep these data responsibly. In India, the Information Act 2000 with various amendments incorporated has been in place since year 2000. It has been serving the purpose of data protection until later it was realized to bring in new special law for the protect data and privacy, especially after the advent of GDPR in European nations. Though the data protection had been debated for long in India, but the narrative around data protection in India reached a crescendo after the adoption of European Union's adopting GDPR, the new data protection bill in 2016, and later heightened further during the hearings in the KS Puttaswamy versus Union of India 2017 right to privacy case, in a landmark verdict where a 9-judge bench of Supreme Court of India affirmed the right to privacy as a fundamental right. During the case, the Indian government set up an expert committee headed by Honorable Justice B.N. Sri Krishna retired to devise India's data protection framework. After a public consultation on a white paper, the committee submitted a draft personal data protection bill and an accompanying report, interestingly entitled "A Free and Fair Digital Economy: Protecting Privacy, Empowering Indians." Finally, the personal data protection bill was introduced into Parliament in December 2019, but to be referred to JPC only for further action. The bill has a very solid foundation and has a very with the stated motivations behind the law. The crux of bills identifies 3 key focal points. 1, right to privacy is a fundamental right, and it is necessary to protect personal data as an essential facet of informational privacy. Second, the growth of the digital economy has expanded the use of data as a critical means of communication between persons. Third, it is necessary to create a collective culture that fosters a free and fair digital economy, respecting the informational privacy of individuals and ensuring empowerment, progress, and innovation through digital governance and inclusion. Not explicitly mentioned in that bill was developed through continued engagement and consultation with a host of stakeholders across India. These interests include Indian law enforcement, desire to access US stored data during investigation, and aversion of so-called data colonialism by large Western technologies firms, grievance against these technology firms we all know, a grievance against large-scale collection of Indian citizen data by Western companies. As this bill was written and was put into internet for expert comments from all corners of nation, it prompted for a need of an organization platform where experts, professionals from data and privacy protection can learn and deliberate the law and its implementation across nation. Its impact across organization in the country. Mr. Vijay Shankar Nagaraja Rao, fondly called as Naavi, here is with us, okay, conceptualized the concept of Dppi, the foundation for data protection professionals in India, and founded it with his co-founder, Mr. Nagendra Javagal, a well-known GRC professional. Naavi, in short, is also a netizen activist with a lifetime mission with the motto, let's create a responsible cyber society. And perhaps later, he had changed it to let's create a responsible data protection professional society, which ended up in a creation of Dppi. Naavi's consistent efforts brought many like us to join the to join the platform, and today we are growing and achieving newer heights in not only increasing the membership but also our activities, especially imparting PDP 2019 and GDPR related education and certification courses. और इसी तरह ये कारवां बनता गया. The objective of Dppi is to create an organization that represents the community of data protection professionals in India and to contribute the welfare of the states besides enriching the community with better and strong knowledge and skills. The main objectives of Dppi listed in the memorandum are to build an empowered community of knowledgeable, efficient, and ethical data protection professionals. Note the word ethical, who contribute to the who contribute positively to the development of secure information society by lawful means without any profit motive. I quote, profit motive, without any profit motive. To enhance the intrinsic value, second number is to enhance the intrinsic value and worth of the professional of data protection professionals who are directly or indirectly engaged in the activity of generating, managing, preserving, and protecting information without any profit motive. The third one is to bring harmony in the pursuance of civil rights of individuals, such as privacy and freedom of expression, along with the right to information and the right to cyber security without any profit motive. Please note the word without any profit motive. So we are a not for a profit organization working in the interest of individuals and nation as a whole. It may be noted that central focus on Dppi is to ensure that the community of data protection professionals will empower themselves with necessary knowledge and enhance their skill set as data protection professionals, or maybe certified data protection professionals, and for doing so would adopt ethical means to achieve the professional goals and also contribute to the national security, recognizing data as a national asset and ensuring the security of data for the benefit of the community. Friends, this year our canvas of IDPS 2021 is much bigger, with the involvement of highly knowledgeable speakers as a speaker and as well as panelists to discuss various aspects of PDPV 2019 and its impact across nations among organizations, institutions, and government functionaries. You all will be, you will all enjoy rich learnings from these eminent speakers, especially Mr. Naavi himself and the Justice V.N. Sri Krishna, the creator of present PDPV 2019 draft, will deliver his keynote today at 6 p.m. Though his keynote was at the start of the day event, but due to some ad hoc urgency, he is unable to join right now, but will join at 6 o'clock. And while I'm keenly waiting for his keynote address, I request everyone here and bring others to listen to his words of wisdom and key point around PDPV 2019. IDPS 2021 has long list of brilliant speakers. Like in legal side, we have Mr. Naavi, Minalal, Mr. Kodandram, Mr. Leme. In technology side, we have Mr. Vijay Sethi and others, Concept and Samir Mathur, Dr. Kamal Karnatak, Annie Matthew, and many more. And Manish from Deloitte is here to enlighten us with his word of wisdom. And okay, I think the bill is perhaps is into the last few iteration before it is passed and put forward for implementation, and would be the next big thing for nationwide implementation after GST. As President of National Governing Council of PDPI, SP Arya, welcome all respected speakers, panelists, and delegates to this latest version of India Data Protection Summit IDPS 2021. And I also welcome new members who wish to join FDPPI in any manner and contribute and its education initiatives for various level of expertise. Thank you very much. And now I will request Mr. Naavi to take over. Thank you. Namaskar.
Thank you, Mr. Arya. Now that you have given a basic introduction to our activities, let me proceed further. The objective of this session is, of course, to introduce the program which Mr. Arya has started, and perhaps a few more points I will add. Then I would like to speak on the challenges which are there to the lawmakers. We are talking of this personal data protection bill, which is getting, of course, postponed again and again. Naturally, we feel that the government is not putting enough efforts to get this passed, but let us see what kind of contradictions this particular bill is likely to address. That is part of what I'm going to discuss. Of course, as far as FDPPI is concerned, Foundation of Data Protection Professionals in India, Arya has already given some basic introduction. We actually registered ourselves as a Section 8 company under the Indian Companies Act in September 2018. So we have completed about 3 years now. This is a company which is limited by guarantees. You don't see many companies limited by guarantees with no share capital. In fact, this company is actually owned by the individual members, the data protection professionals, not by any big, say, promoting organization, nor even, of course, the government. So that way, this is a bottoms-up company with the professionals actually, through their membership, actually contribute the corpus. And later on, of course, we are trying to generate certain revenue out of the certification programs and other things. But basically, this is an organization of the data protection professionals, by the data protection professionals, and of course, for the data protection professionals. Myself and Nagendra Javagal are the two directors. This is actually a private limited company. And we have a National Governance Council and also a National Advisory Council. National Governance Council, which was elected from the members of the FDPPI, has Dr. Arya as the president. We also have Dr. Mahendra Lemye of Nagpur. Arya sits in Delhi. And then we have got Ramesh Venkatraman, who is in Bangalore. Anil Chiplunkar, who is in Mumbai. Samir Mathur is also in Delhi. Then we have got Adepu Bondaya, who is in Bombay, Dr. Mahalakshmi in Bangalore, and Reena Bengeri in Bangalore. So we have a fair distribution geographically of professionals who are in different places. And then we have created the National Advisory Council consisting of the senior members of FDPPI, most of them who have been with us right from the day one. Dr. Rakesh Goyal of Bombay, Meena Lal from Delhi, Ramesh Kauta, Wing Commander S.K. Prakash, Kodanda Raman are the members, and additionally Ashish Khanna represents the group of CIOs, and Rajiv Panikkar represents DNV, who is our partner in our activities. So therefore, we have a fair distribution of professionals in the managerial structure, though for the time being, you can say that people like us are taking the lead. Sooner or later, it is the group of these professionals who will be taking this particular organization forward. We have created a structure of 45 supporting members. These supporting members are like 45 arms of FDPPI, and any activity which the FDPPI has to undertake, whether it is a training or whether it is a audit, will be undertaken through this supporting members. So what we have done is, instead of creating an organization where we pay salaries to various general managers or something like that, we have actually created individual entrepreneurs like profit centers consisting of these 45 supporting members who are able to execute certain projects under a revenue sharing plan with the FDPPI. That is a structure which is actually taking us forward. There are about 91 members who are in the category of foundation members, another 62 basic members. We have created 9 certification bodies which will be certifying the personal data protection compliance management system under the what we have called as a personal data protection standard of India, which will briefly, I will tell you about it a little later, to implement that plan of action of looking at the compliance of organizations, helping them in putting together the compliance system and certifying them. We have created 9 certification bodies. Additionally, so far, we have created nearly 200 certified data protection professionals who have been provided with an intense training on the data protection laws of India, data protection laws of the other countries, including GDPR, Singapore, CCPA, and so on, and also the data audit skills. So these are the 3 different skills which we have tried to impart during the training programs, which we call as a DPO training program. As Dr. Arya was telling, FDPPI has some unique objectives. One, of course, like many other organizations of similar nature, we also want to create knowledgeable community, which is what we do when we have these training programs. And it is not enough if we are having only the knowledge, the skills also have to be developed. That is the data audit skills, which we cover through efficiency. And as we already pointed out, we are all interested in seeing that our professionals follow an ethical standard wherever they do, and they contribute to the development of a secure information society by lawful means. Lawful means is a word which many of the privacy people are aware that when we are talking of collecting of data, whether it is under GDPR or other things, we say lawful means. You have to only collect personal data through lawful means. Now we are saying that our organization has at the top of their mind that whatever we do, we have to do it through lawful means. Of course, every company tries to do that, but it is always helpful if we make that visible to all our members. Visibility of certain things helps in better management, as I will also explain. In terms of data valuation, which we are trying to push through, we always feel that visibility of the value of data in an organization is very, very important for compliance efforts. So likewise, we want every one of our members to remember that we are here to be an ethical force. We don't want to deviate from that ethical force. We always want to follow the lawful means. Compliance, we are telling others, basically we also have to do compliance. Of course, we are still a startup company, so there are many shortcomings in us, but we are having this as our goal. Then enhancing the intrinsic value or worth of the community is important, because if we do good work, then obviously the community will get a better name. That's why we feel that whatever efforts we are doing, it adds to the value of data protection professionals. After all, FDPPI is only a not-for-profit organization, so any value which is added to FDPPI is only like an increased reputation. There is no possibility of any profit being distributed to the members or something like that. But what we want to do is that the whole community of data protection professionals should feel that they are a respected community in the industry space. This harmony is something which we are looking at, because we often find that privacy activists fight with the right to information activists, or even security proponents. See, for the national security reasons, sometimes there are differences of opinion between the security agencies and the individual privacy activists. So we cannot forget that privacy is a complicated topic where there are inherent say conflicts between 2 or 3 say even fundamental rights. Therefore, we feel that there is a need for us to remember this always, and so our objectives highlight that bringing harmony in the society between the privacy activists on the one hand and the law enforcement people and others on the other hand is also part of what we need to do. Towards this, we have built up several activities. One activity is the knowledge enhancement related activities, where we conduct frequently what is called Jnanavardhini webinar series, where we try to pick up different topics, and one of our members or some invited guests will speak about a topic of interest. Then we have a Data Protection Journal of India, which we are trying to bring it once in a quarter. We have completed about 4 journals in the last 1 year. We have our certification programs, and we have also reached out to the colleges, so that privacy and youth as a program we want to develop, so that even the students coming out of law institutions or even engineering institutions, they should get some hang of what is privacy, so that the privacy culture gets developed in the nation. In terms of implementation support, we are looking at the PDPSI, Personal Data Protection Standard of India, which is a standard which incorporates the best practices and the best standards which are otherwise available in the world, and it focuses on India in particular. This is a unique contribution to the society according to us. We are working on a dispute resolution mechanism online called Data Disputes Mediation and Arbitration Platform, so that the persons who have specialization in data protection laws can try to provide a grievance redressal mechanism to various companies. As we know that once the PDPB becomes a law, grievance redressal becomes one of the important activities of most of the companies. So we are trying to develop that as a platform and let the legal professionals take advantage of that, besides our contributing to the community with an informed arbitrator or a mediator trying to resolve the disputes which may be between a data principal or a data subject and the data controller, or between a data controller and a data processor or a subcontractor. So it may be a B2B dispute or a B2C dispute. We will try to address that. In terms of mediation, it will definitely be there. In terms of arbitration, since the act itself will have an adjudication and then appellate tribunal and other things, we may have to restrict to non-binding arbitrations. Otherwise, mediation, of course, will definitely be there. We are also in the process of developing what we call as Data Protection Emergency Response Team, DPI or team. We all know that CERT is there, which also takes into account the following up of and providing advisory on cyber security issues and looking at the potential cyber crimes in the global segment. what we may try to do is to focus more on data protection related emergencies, which may arise because of course, the kind of cyber crimes, which are also part of CERT, but also try to help organizations to actually come out of any emergency situations related to data protection related issues. So we are in the process of building a team of say volunteers who may be able to work in this particular area, which will be one of the first of its kind in the, I think, the whole world. If you say CERT represents the cyber crime related things, you have got many such organizations, but an organization of similar nature focused on data protection may not easily be available in other places. Now, as far as our certification programs are concerned, the uniqueness of our certification program is that we recognize that data protection related expertise is a combination of technology and law. And we have CISOs, we have CIOs. Now, many of them would like to get into the DPO segment. So we need all of them to get good knowledge of the relevant laws, which is data protection laws. Additionally, the lawyers also would like to perhaps learn a bit more of audit and technology. We are trying to therefore build a training module where we not only teach people about the Indian law as well as the global law, and then go for audit modules. You may ask me what is there in Indian data protection law. In fact, we are having multiple sessions to discuss about the past, present, and future of the Indian data protection regulation. Unlike one of the popular views that India doesn't have a privacy law, we must say that ever since the Information Technology Act 2000 came into existence, which is 17th October 2021 years back, there is some form of a law for protecting data. In IDEA 2000, of course, tries to protect both personal data and the non-personal data. And in 2008 amendment, specifically the personal data, some extra emphasis was given. So we already have some form of data protection law. Whether it is sufficient, not sufficient, we can always debate. And now we are moving into a specific personal data protection regulation itself. So we will discuss that in module I. There are a number of people, professionals, who have got qualifications in GDPR and something CCPA or something else. But what we are trying to tell the professionals is that if you are working in India and an Indian company is collecting data and processing data, if it is from EU, perhaps you need GDPR. But if the data is from India, you should know what is Indian law. So without a complete understanding of the Indian data protection law, no data protection officer in India can consider himself as well equipped. So we are trying to actually ensure that the Indian law is also adequately discussed. And the audit module, we discuss about the DPIA, data protection impact assessment, and harm audit, which is a terminology which we try to use. We have, of course, the breach, data breach related audit. And in India, what the law has initiated is that you need to have a PBD policy, that is privacy by design should be reduced into a policy, and you should get it certified with the Data Protection Authority. So Indian privacy by design concept is much different from what we see in GDPR. And over and above that, we have the system of data trust score. So to conduct an audit with a eye on data trust score, which is a measurable aspect of how good a company is in privacy protection, it requires a slightly different mental attitude and maybe a little different skills. So we are trying to put that also as part of this module A. Presently, of course, we have about 36 hours combo program for all these three. We also have online examination for 90 minutes each, 3 examination. And we have got our tie-up with the DNV, which is one of the globally renowned certification agencies, so that some of our certificates are issued as FDPPI DNV certification, and even our DTS system may be co-branded as FDPPI DNV. And so our efforts could perhaps not only serve a large community of people in India, because DNV has got such a large reach, and maybe sooner or later we will be taking our Indian concepts to the world. That is why we call our PDPSI system as made in India for the world. Okay, that is our future vision of FDPPI. This PDPSI is going to make a substantial difference to the current compliance programs, and it will perhaps disrupt some of the existing notions, because we generate trust score, data trust score, and we try to develop this as a unified framework, because if a company in India is having multiple data protection laws to be contended with, worldwide we know that there are more than 130 different data protection regulations. While internet can take us anywhere to the globe, the data protection laws of each country will say, when you are collecting information from my country, please be careful, I will have a regulation, and my regulation has got extraterritorial jurisdiction. I may come and do something in terms of collecting penalty from you. So Indian companies need to develop a framework which will not only satisfy the Indian law, it will not only satisfy the GDPR, but maybe many other laws like an Australian law or a Singapore law or a Dubai law, or different states in USA. USA is trying to develop a system where each state will have its own data protection law, unmindful of the problems which the compliance community will have. It is easy for us to write a law and say, I have got the jurisdiction and therefore I will pass a law. But the compliance people, that is the organizations, need to understand the law and put it into compliance. And if 130 countries and another 40-50 states of USA, 200 countries have got 200 laws, nobody seems to understand that the compliance becomes complicated, and more complications means less efficiency in compliance. So unless we have a simplification of these laws, we run into a problem. Okay, we cannot tell the governments to make laws simplified, but the compliance system we can unify. That is what we are trying to do. We are trying to make it an open standard so that it can be used for self-implementation by organizations, but they may need a little bit of help, so that they may take help of consultants who are PDPSI certified, and maybe they can also go into the certification of audit itself with people who are certified as PDPSI auditors. FDPPI is taking the responsibility for that. And what we are doing incorporates the best practices of ISO 27701 and goes much beyond that. And probably on the third day of this conference, we will have a separate panel discussion in which we will be introducing why PDPSI is such a unique facility. And as I told you, FDPPI DNV collaboration brings this FDPPI DNV data trust score. And when in 2018 version of the PDPB, DTS score was mentioned, nobody took a second look at it, but we went about developing a base system. And today we have a base system linked to the PDPSI, and we can perhaps say whether you agree or not, whether you dispute or not, we can say a particular company data protection system is having a DTS score of 62.3, something like that. Maybe in future there will be other people who will be coming up, but we will be called the pioneers of this data trust score system in India. And we are happy that DNV has recognized this and wants to work along with this. Now, these are some of the things which have gone to our planning of this particular conference called IDPS 2021. It is, of course, the flagship program of FDPPI. This is the second edition. Last year, IDPS 2020 was held more or less in the same time period. But remember, last year we had only 6 sessions. This time we have got nearly 18 sessions. So 3 times the number of sessions, that many people who are there, industry professionals who are coming here to share their knowledge. And therefore, this has undoubtedly become the biggest event in data protection in India, and it will remain like that in the coming years. Perhaps more of you who are today sitting there as an attendee will be part of our management team, and we will be able to expand this much bigger than what we are doing today. We are covering law, technology, and managerial aspects. There are more than 50 speakers, and there are keynote sessions and 9 different panels. The details of the speakers and others are available in the documents which we are making it available. You can go through it. Just to give you an example, if you take today's program, after this inaugural session, we are having a panel on new career opportunities as DPO and data auditor, because we feel that data auditor also is a career, because Indian law again mandates annual data protection data audit to be undertaken by all significant data fiduciaries from an external auditor. So there is a requirement of external data auditors in India, and we are trying to build people who are capable of doing that, not only working as DPO within the organization, but working as data auditors. And then we will be discussing aspects of big data and digital marketing, which are the 2 important industries which have been hurt and challenged by the data protection laws because of the restrictions which are imposed in terms of privacy. So we will discuss about that. And then around 6 o'clock, Justice Sri Krishna, who was the author of the data protection regulation, made an extensive international study of the data protection laws and came up with not only a report, but also a draft bill, PDPB 2018. He himself will be present here to share his thoughts on the data protection laws, how they are emerging in India. Then immediately after that, before we start the next panel discussion on the data protection laws in India, we have a session in which we are giving an award for the person whom we call as the data protection champion as far as India is concerned, recognizing the commitment and achievements of one individual in India. Of course, it is a challenge to identify a person like that, but we have done our best, and we have not gone for going for, let us say, a person to make an application for an award, because we feel that any good person will not make an application for the award. It is the responsibility of the community to recognize their ability and then try to give an award. And if they accept the award, that itself is a kind of say honor for us. So this is a something which we call as a commitment for us to ensure that the market gets inspired by somebody who does a good work and who is recognized as a person who is given an award. So that we will try to do it at 6:45, and a short program in which our data committee chairman will announce who is the winner of that. Then perhaps we will be having him personally available here to give an acceptance speech. And then we will be winding up the day with the data protection law, past, present, and future. Then tomorrow we will be having Dr. Triveni Singh, the person who is called Cyber Singham in India, a law enforcement person, to discuss about the challenges law enforcement is facing from the privacy. Then we will be having the discussion on the impact of GDPR, including the standard contractual clauses. Then we will be discussing the employee-related privacy issues and the role of HR. And then we will discuss Industry 4.0 issues. And then we will be coming to the technology tools and the privacy risk. So Between these sessions, we are discussing GDPR. The keynote of Rajesh Vishwanath will also talk about GDPR and the standard contractual clauses. So we will have a wide discussion on different aspects of GDPR and technology tools and these employee-related issues. The last day, we will have a keynote from Dr. Sardev Singh, who is the Undersecretary in the Ministry of Law. And then we will be having a panel discussion on innovation. Then we will have another keynote from Rakshit Tandon, a well-known social media specialist. Then we will be having the compliance-related issues discussed between one keynote from Ramesh Venkatraman and a panel. And lastly, we will be discussing the challenges in data valuation, which is a completely new topic which we are pioneering, and we are trying to tell the accounting community that you have to find a way to find out the value of data and bring it to the balance sheet. Don't tell me that when something goes wrong, the hacker is asking 1,000 crores ransom, and until that time, many of the CEOs will think that I never knew that we had so much of data with us. So we don't want such a situation. If management has to be proper, if we want a DPO to be appointed with the kind of say rewards which he expects, the management has to realize that I have got 1,000 crores worth of data, which has to be protected. Therefore, I need a DPO. I have to send him for trainings, and I have to ensure that I pay him well, and I have to equip him with the tools. So for the management to actually take say efforts, we need this visibility of data as a valuation. So we are going to discuss some aspects of that as a new topic. So this is how we feel that this particular IDPS is going to give you a bird's eye view of several of the things. Now, in another short time, I will try to just highlight what are all the challenges which these panels are going to discuss in various points of time. First of all, we must recognize that this data protection law in India is a sort of a legal maze. Why do I say that? Because this data protection is actually a human right issue, which is part of the constitutional right. Now, Puttaswamy judgment also is interested because the privacy is a right which should be guaranteed to the citizens of India. So this is the human rights dimension of privacy. But when we discuss data protection today, we are all industries, we are IT companies, and we handle personal data. How did this human right protection became an obligation for the industry is a very interesting transition. And we started, as I told you, with ITA 2000. Then in 2016, we had the first bill, which was actually presented in the parliament, PDPB 2016, which actually came along with the Amendment to Information Technology Act, which was proposed at that time. That Amendment to Information Technology Act became a law subsequently, but the PDPB remained without a probable this thing. And actually, this is not even 2016. I'm sorry, it is PDPB 2006. Okay, so 2006, in 2008, actually the ITA 2000 became the law, but this simply got neglected. Then we had this 2018 version with the Shri Krishna brought out, which was slightly modified and represented as 2019, because in between the parliament actually completed its term. So a new parliament came, so a new bill had to be presented. And this 2019 version is still there with the Joint Parliamentary Committee. And probably this will be the one which will be seeing the light of the day in 2021. Now, the new JPC, earlier JPC had about, I think, 69 or 70 sittings under the chairmanship of Meenakshi Lekhi. In fact, we also from FDPPI were invited to give our views. We have done that. A lot of discussions took place along with experts, legal people, and the companies like your Amazon and others. They were all called and their views were taken. But when 2-3 important people of the committee became ministers, like Meenakshi Lekhi went as a minister, then Rajiv Chandrasekhar became another minister. There was a reconstitution of the JPC, and the new JPC under the chairmanship of P.P. Chowdhury has taken some efforts to give some final touches to the bill. Of course, media speculation is there that there will be so many changes that it will become a totally different law. We don't know. We don't know whether it will be completely revised or perhaps only cosmetic changes will be there. But there are 4 specific say changes which are being spoken about in the media. One is that when we talk of data breach notification, the personal data breach notification is what is being addressed by the Personal Data Protection Bill as of today. Now, there is a move to add data breach notification related to non-personal data also as a responsibility under the PDPB, and similarly, the Data Protection Authority under this act, who would have been a Personal Data Protection Authority, is expected to also be recognized as the Data Protection Authority for personal and non-personal data. As of today, as you know, Information Technology Act is the law which takes the data protection regarding non-personal data because it is considered as a cyber crime. And the 43A of the Information Technology Act, 43 capital A of Information Technology Act, which addresses the personal data related issues, is going to be replaced by the PDPB. So currently there is a distinction between ITA 2000, which will focus on protection of non-personal data. PDPB will look at protection of personal data. Therefore, a data breach of a non-personal data comes under Information Technology Act and goes to the CERT-in, whereas the breach under the PDPB will go to the DPA, that is the current structure. And probably people think that this has to be slightly changed. Certain powers should be transferred to this DPA. We will see what will happen. But the other more important aspect is, you know that after GDPR came, the administrative fines were expressed as a percentage of the global turnover, 2% or 4%. And we have seen at least one instance where Amazon has been fined something like 880 million US dollars. See, the problem is that quantity of say fine is being imposed by a country called Luxembourg, and which has a population much less than that of Goa. In fact, this fine which they are trying to collect from one company, Amazon, is creating a per capita income for every citizen of Luxembourg equivalent to something like 1 lakh of rupees. So there are this thought process that if you have such astronomical level of fines, then people will be more responsible, otherwise they will not be responsible. Whereas if you have it at a lesser level, then people will ignore it. Probably that may be true, we don't know. In fact, this fines at 2%, 4% was one of the important reasons why GDPR was taken so seriously across the globe. Now, PDPB 2019 also talked about 2%, 4%, but there is a thinking, at least as per the media reports. We can never believe the media reports are always correct, but the media reports say that there is at least some suggestion that this percentage-based penalty should not be there in the law, because there is no other law in which percentage basis penalty is normally levied, and it should be put at some figure, 10 crores, 15 crores, maybe even 100 crores, we do not know, as the maximum fine. So this will be one of the suggestions which the JPC is considering even as of today. In fact, tomorrow there is an important JPC meeting. These things will all be perhaps reviewed and presented tomorrow. We may not know what they have presented because it's a confidential information, but by tomorrow some of these decisions would be there. Then similarly, there is some provisions regarding social media intermediaries, some provisions which there is a thinking that it may be deleted. I already spoke about this data breach notification. Presently the CERT-in is the authority, and the proposed move of the Data Protection Authority under PDPB also being responsible for receiving non-personal data breach reports will actually interfere with the powers of certain which are quasi-judicial nature under section 70 capital B of IDA 2000. And it will also to some extent disturb the concept of non-personal data governance law, which Chris Gopalakrishna suggested as a means of monetizing non-personal data. Now, by mixing up the two, we don't know whether we are actually bringing better clarity or making it a little more confused. So DPA, if it is combined, then, and also another thing, this Chris Gopalakrishna committee was very clear that personal data protection will be handled by PDPB, but if personal data becomes non-personal data, either by anonymization or by any other reason, we will address it through a separate law. And this non-personal data, the basic aim of the law would be how to help companies to monetize this non-personal data. That's why he defined something called data business and tried to produce some kind of a channel for monetization of non-personal data. And now whatever is being proposed may perhaps try to disturb this balance which is being struck between the IDA 2000, PDPB, and the non-personal data governance. So let us see what will happen. And this reduction from 2%, 4% to 10 to 15 crores, maybe some people may think that it is a giveaway to the organizations, business organizations, which may be to some extent true, because Twitters and Amazons will not worry about 10, 15 crores. In fact, in banking segment also, 1 crore fine is often made by RBI. Nobody cares, no bank cares for that. So deterrence will not be achieved by a smaller fine. So maybe we may come back to 2% or 4%. Ultimately, when an adjudicator defines what is the fine, he may always take a discretionary decision not to impose the maximum of 4% of the global turnover of Amazon or something else. He may still come to 10 crores, 15 crores, depending upon the circumstances and the gravity of the situation. As far as the social media intermediary provisions were concerned, what PDPB wanted was that every social media intermediary should allow people to voluntarily verify their accounts in a manner to be specified, and the social media intermediary like the Twitter and others should make it available to the public. And this intermediary guidelines of February 25, 2021 also spoke about this. So one of the arguments which has been presented is, since IDA 2000 is going to handle this, why is it necessary to put it in the PDPB? We will wait and see what happens. But we know that the regulations of the intermediary guidelines have been challenged in the Supreme Court, and the same people who are trying to bring in this concept of objecting to these changes, they're actually saying that IDA 2000 was not meant to control the media, social media. Therefore, it is ultra vires the Information Technology Act, and they have gone to the Supreme Court to get the order scrapped. So if that is scrapped there, and if it is also removed from PDPB, social media intermediaries will again go free to work on fake news, to make money out of fake news and so on. So this particular provision needs to be retained in PDPB so that the social media is responsible. Now, there is also an issue which arose out of this EU-CJ decision, where the European Court has brought in so many regulations regarding data transfer, and EDPB guidelines to say that the data importer in India has to provide some kind of a standard contractual agreement to the data exporter. And some of these changes which they are suggesting are actually very strange, in the sense that we know that this Schrems II decision actually brought down the privacy regulations of the US Privacy Shield because of two reasons. One, because the US intelligence would be having access to the data they didn't want. And secondly, the EU citizens wanted to have recourse in US And that recourse was provided by Privacy Shield through an ombudsman. But since the ombudsman was appointed by the president, EU court said that I will not trust the US president appointing an ombudsman. He may put his own family member there or a person like that. So the distrust of the European Union system with the US resulted in the Privacy Shield being rejected. And if that has to be now guaranteed by the standard contractual clauses, an Indian importer may have to give an assurance that there will be, for example, these are the conditions which they're asking. One is data subjects should be able to, data subjects of the EU who are foreigners for India, they have to be able to invoke where necessary and enforce the standard contractual clauses as third-party beneficiaries in India. In fact, what is being asked is a sort of an extraterritorial jurisdiction being created out of a contract between two private parties. I don't know whether this is the right way of doing things. What we have suggested to FDPP, to the Personal Data Protection Authority, that is a JPC, is that the Data Protection Authority of India should actually try to protect the Indian data protection data processors by ensuring that no penalty or liability should be imposed on an Indian company except through the DPA. That is, there should be an umbrella of protection given by DPA, so that we don't want a EU company to send a notice to an Indian company saying that you have to pay me 200 crores or 300 crores or something like that. That will be debilitating for the Indian company. So therefore, we wanted actually the DPA to take some responsibility. Maybe this is something which needs further discussion. Very recently, the data empowerment and protection architecture, which has been adopted by the Reserve Bank of India, has been using a terminology called consent manager, which was actually a terminology which was introduced by the PDPB. Credit should go to Justice Sri Krishna for introducing this concept of this consent management. But in the Dppi framework, it has been used in a different context, like an intermediary who comes under the Information Technology Act, like an ISP, he is actually called a consent manager. So there is a need for some harmonization of the new laws, there is sectoral regulations which the government is bringing, because this account aggregator concept is being extended to the health sector and to the telecom sector. And it is likely that this Dppi architecture will become a standard of its own for consent management. That is, how to get the consent from a data subject, how to collect the data from a data provider, and how to give it to the data requester. Okay, that triangular distribution of consent-based personal data will be addressed by this Dppi architecture, and it could become a standard of its own. And it has to be, of course, compliant with the PDPB recommendations, which says that the consent manager is a data fiduciary. The consent manager of a PDPB will have visibility to the data, whereas the consent manager under the account aggregator will not have visibility to the data. So there is a major difference between the two. Further, we are seeing that there is a demand for exemption from the PDPB regulations by organizations like RBI and UIDAI. But if we see that the PDPB makes even the Data Protection Authority a data fiduciary, I don't see why these other organizations should not have the responsibility. Maybe we will discuss this in some of our sessions. There is also a demand for state level DPA. This again is already possible under the current regulations. We don't need the change of law for this purpose. But unfortunately, many legal changes are suggested just to ensure that the bill gets, prolonged. Now, data valuation, I already said that there is a need to bring visibility to the data so that the management knows how much of assets it is protecting. At the same time, in mergers and acquisitions, the data value is not forgotten. We had two important incidents in India where data valuation was forgotten and a larger society loss was recognized. One was There was a company called Net4 India, which went into liquidation recently. It had about 100 crores worth of data, which was given a zero value by the person, whoever was looking at the say insolvency criteria, resolution professionals, because there was no system for valuing data, and the company was declared insolvent, and a number of individuals had to take a lot of losses arising out of this. Secondly, there was an organization called CIBIL, which holds a huge amount of sensitive personal data in India, which had 80% of shareholding by the Indian banks, but without anybody recognizing this 80% shareholding of Indian banks like the State Bank of India or Canara Bank or somebody, they were all transferred to a US based company. And today 90% of the valuation of the shares of this civil TransUnion belongs to TransUnion, which means that along with that 90% change, the control on 100% of the data goes to TransUnion. So nobody remembered that when a company changes hands, it is not only the visible assets like your computer, building, land, etc., but also the data which is important. And because we don't have a system of bringing the valuation of data into the balance sheet, these things are happening. Compliance framework, I told you that we are working on this new framework. Again, there will be a session for discussing that. There are issues of anonymization, whether anonymization requires prior consent. This is also one of the things which the new JPC may be thinking. And as of now, if personal data is anonymized, then it becomes non-personal data. So there is no problem, it can be monetized. Now they want a prior consent for anonymization, which means that the data analytics companies will find it difficult to discover new users of anonymized data. If they discover a new use, they have to go back to the data subject and say, I collected the data without telling you that I have got some use for anonymized personal data, and now give me a consent. Most of the subjects don't give such consents, which means that there will be some kind of a difficulty in implementing new kind of projects. Of course, PDPB recognizes something called a sort of a provision whereby some testing and other things can be done in a separate sandbox kind of an environment. And that is one of the unique features of the Indian law. Why we say that Indian law has to be studied is that this is not a replica of GDPR. One of the things which every professional has to remember is, please unlearn what you have learned in GDPR before learning the Indian law, then only you will make a good DPO. So it is not only because the concept of data fiduciary has been introduced instead of a data controller, PBD policy will be certified, right to forget has become under Indian law in something which the adjudicator has to intervene, the sandbox system, then exemption for processing of foreign data by the Indian companies by a notification, a provision which BPOs should be actually talking about as a great provision, but nobody seems to recognize this because very few people have studied the Indian law to the depth which is required. They study the GDPR, but they don't study Indian law. Like many of the Indian banks are compliant to the Patriot Act of USA, but if you ask them whether they are compliant to ITA 2000, they have no clue. Same thing is happening in this PDPA. That has to be broken. Data trust score, mandatory data audit, DPOs as employees is another special feature of this particular law. Now, big data and AI, we are going to discuss in one of the sessions. See, we are talking of profiling. See, who does the profiling? Profiling is done by the machine. Now, when the profiling is done by the machine is not knowing whose data it is, because the identity of a person becomes relevant when a human being interprets the data. That is why we say under the theory of data that the data is created by technology, but data is actually perceived by a human being. So, and the human being perceives it through various devices like your computer, the software, application, and so on, without which Data remains binary, zeros and ones, zeros and ones. It has got no meaning to the human being. The meaning is ascribed by the technology. Now, if the technology looks at the data and anonymizes the data within its process and releases an anonymized processed data, the question is, are we violating the privacy of the individual? Because, of course, technically you can say admin of this particular AI algorithm can look into the data, but it is an exceptional process. So in fact, this concept of whether visibility to the machine should be equated to the visibility to the individual needs to be looked at. And this is the concept of privacy 2.0, which we need to look at. Unfortunately, whatever we do, there is always a political interference in the creation of laws. I hope PDPB will come out of this, and it will take, the JPC will take the views of the professional community and then perhaps will bring out a law which is better than what it is. And in fact, after the conference is over, we will be perhaps be able to present the findings or recommendations of this conference to the government once again. So we are definitely looking at all our speakers placing their views, not only during the conference to the larger audience, but we will also document it and present it to the government. And with this, I would like to close my session.